The House Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews.
Present.
Oh, he's right there.
Carter.
Present.
Breen. Young.
Here.
Arpit. Stevendorf. Cerniglu.
Here.
Filler.
Yes.
Mueller.
Here.
Bazat.
Here.
Harris.
Here.
Bagol.
Here.
Madam Chair, you have 10 members present. You do have a quorum.
Thank you. We'll now hear testimony on House bills. Oh, excuse me, I need to adopt the minutes from the last meeting. Representative Carter moves to adopt the minutes from the September 19th meeting. Without objection, the minutes are adopted. We will now hear testimony on House bills 4945 and 4946. Here to testify in support, Representative O'Neill. Or not. While we're tracking him down, could we please have Heath Lowry come up and Kaja Kelly, if you could come up as well and after Heath give your story. Thank you.
Good morning, representatives. Happy to be here. My name is Heath Lowry. I come on behalf of the Michigan Coalition to End Domestic and Sexual Violence, where I proudly serve as staff attorney to our organization and as a voice for our organization amongst you all here in the Capitol. The Coalition is a nonprofit that represents over 70 domestic and sexual violence and human trafficking service providers across the state, representing survivors in each county. In addition to being a voice here in the Capitol, I also serve as an attorney to survivors in state and tribal courts across the state. A diverse geographical and social set of courts in every community, but there is one through line for all those communities: the lethal risk of domestic violence and firearms. I use my experience on the front line to inform every bit of advocacy that I make here. And in that capacity, the Coalition and I ask you to support these bills, House Bills 4945 and 4946. And standing beside survivors in these legal systems, I've borne witness to the panic and the dread of survivors when they realize the truly short length of time for the perpetrator's trip to jail. Safety planning for the moment of release has the near impossible task of accounting for a perpetrator who can legally possess an instrument, a weapon that can end the survivor's life in a flash. This sort of hypervigilance wreaks havoc on many survivors' ability to function even when the perpetrator is facing accountability. They have to be on guard in their front yard of their home, on a break from work, in the parking lot of a grocery store, or any other everyday place that we all go about our lives, because those are places where abusers have ended the life of victims. Convicted abusers have exhibited that they are dangerous, and the statistics bear that out. In most cases, there is a long history of domestic violence before the first conviction. There are structural and societal barriers to achieving that conviction for a misdemeanor involving domestic violence. These barriers persist in spite of years of improvement made by efforts of survivors and advocates alike. The pattern of behavior of domestic violence escalates over time, and a short stint in jail does not often break that pattern. In fact, the most dangerous time for survivors is often when they engage with law enforcement or some other means to separate themselves from that relationship. Further compounding that danger, when an abuser has access to a firearm, it's 5 times more likely that the domestic violence will end in the death of the victim. This serious risk warrants a serious response. And the protections laid out in these bills, just like in other states, can save lives. And these lives are important. And they deserve to be around, but they would otherwise be extinguished by the actions of a selfish individual otherwise. So again, I ask you to support these bills, and I'd be happy to answer any questions.
Thank you. Before you get started, Ms. Kelly, I see that Representative O'Neill has joined us. Would you like to speak, or?
Whatever order you want me to speak, Madam Chief.
Please do.
Traffic never fails, 69. Good morning, Madam Chair, members of this distinguished committee. Thank you for this opportunity. Just like to say, really excited about this bill package. The bills before you are ones that I care deeply about. I've worked on them with Senator Chang for the past 2 terms now, and I'm elated to see these receive the committee hearing. Thank you. These bills prohibit abusers convicted of misdemeanor violent crimes from possessing firearms. Michigan is now part of the minority of states that do not prohibit abusers convicted of misdemeanors domestic violence crimes from possessing firearms. It is time that we make this change. I could go on, but I do not want to take away the time from the precious colleagues that we have here and some of the testimonies that will take place. And I ask that you support these bills and welcome any questions. As you know, we have MOMS, the Man Action, Michigan Coalition to End Violence, Sexual Violence, Johns Hopkins Center for Violence Prevention, experts here to entertain any questions that you may have, Madam Chair.
Thank you. Now, Ms. Kelly?
Thank you all for being here today and listening to a part of my story. Domestic violence is dark and insidious, affecting countless individuals and families worldwide. It doesn't discriminate. It crosses all social, economic, and cultural boundaries. I'm here today as a mother, a clinical social worker, an advocate, and a survivor. Please forgive me as I might cry. I want to shed light on a particularly harrowing aspect of my life. My then 2-year-old daughter and I were threatened by firearm, specifically my husband's handgun, the same gun I practiced on and used to obtain my own CPL. I'll never forget the first time he threatened us. It was an early summer day, the ones in Michigan where you're excited for summer. I was outside holding my daughter and watching my husband grill. Without provocation, he turned to me, deadpan, and said, "If you ever try to leave me, I will kill you and our daughter, and then myself in the shed." He then took my daughter from my arms and continued grilling. I stared back, tears welling in my eyes, and panic coursing through my veins. I knew we were in trouble, and I had to get out. It was time to safety plan. I began backing up my car instead of pulling in, making sure I always had a full tank of gas. The battery in my phone was always at 100%. I packed getaway bags, one for my office and one at my parents'. I hid the gun keys at night. Not only did he have one handgun, we have several, including an AK. But I hid them especially when he was drunk and in fits of rage. I was terrified night and day. For safety, I only let my parents and one close friend know about the abuse inside our home. He's a small business owner and loved by people in our community. You would never know. And in part, I was too ashamed to tell. What would that say about me? In a devastating turn of events, only 1 month after the first time I physically left him, I was diagnosed with triple-negative breast cancer. I found myself completely helpless. Instead of caring for me and my daughter, he chose to continue the threat of violence. He didn't come to chemotherapy infusions, and on one occasion, I had to walk halfway home after my port was placed. Day after day, he chose himself. While my hair fell out and my body weakened, he went to the shooting range, jetted off to the Bahamas, and drank himself into oblivion, all the while reminding me it would only take seconds to end all of our lives. In July of 2022, after one particularly chilling incident, he threatened to rape and kill our close family friends, as well as their daughters. While my body was crumbling from the weight of the chemo, I said no more. With the support of his family, my friends, a competent attorney, and a judge who believed me, provided an ex parte order, and I left. There isn't a day that I don't look over my shoulder. There isn't a night that I don't double check my logs. This last weekend, I had the shed demolished, leaving only bricks on the ground. I'm not here to dwell in the darkness of those days. I've survived cancer, and I sure as hell won't go down without a fight now. My pain will become progress for my daughter. I feared turning him in, and still do today. As an advocate and a social worker, I know my daughter and I are not protected. Those guns are still in his possession. Had there been a law in place where I knew without a shadow of a doubt that his guns would be taken in a timely fashion, I could have left. I would have left sooner. I'm a gun owner. I come from a family of gun owners. I'm not asking for any law-abiding citizens for their guns to be taken. I'm asking for my right and my daughter's right to life. I'm asking you to please hear us, close the loopholes. This is common sense. Stand with us. My daughter's name is Eleanor. She deserves safety and her mother's safety. And your children and your grandchildren deserve safety from someone who's been convicted of domestic violence. Thank you.
Thank you. We'll now have Rick. Are there any questions? No. Go ahead.
Thank you, Chair. Thank you, Representative Heath. Thank you for coming and testifying. Just wanted to talk about the bill real quick. And Representative O'Neill, I'm going to have to pull it up real quick. I believe this says, let's do this. Is it 8 years? You're prohibited for 8 years? Is that how the bill's written? Heath, I just want to confirm.
Yes, after the end of the sentence. Yes.
Okay, and that's for a misdemeanor. So if you're convicted of a misdemeanor, then you have to wait 8 years after the end of your sentence before you can purchase a firearm.
A misdemeanor involving domestic violence as listed later in the bill.
That's right. Okay, there we go. But if there's and I think I'm reading Michigan law right, if you are convicted of a felony, you have to wait 3 to 5 years. It's 3 years. It's either 3 or 5 years. So I guess my question is, why are we doing 8 years for a misdemeanor when you have to wait 5 years for a felony, when a felony is more serious than a misdemeanor? Unless I'm reading it wrong.
You're not reading it wrong. There is frankly, the math on a felony, the amount of time someone spends in prison, and the subject of that sentence afterward is longer, and a misdemeanor by definition is less than a year. So the 8 years on top compared to the felony, the time of the sentence plus the time after the sentence are roughly equal.
So you're trying to equalize them by making the misdemeanor 3 to 5 years longer than the felony.
And frankly, the misdemeanor domestic violence is a stronger red flag for future danger than some of the felonies that are under the prohibition.
Thank you, Chair. Thank you, Heath. Thank you, Amos.
Representative Devendorf.
Thank you for being here. We always so appreciate your support. There are very few experiences in my life that I don't feel comfortable, safe enough to talk about. And I'm not going to today. I have before. I hope we get to a point where we don't ask survivors to share their trauma for us to take it seriously. I hope to God, yes, God, that we don't keep renewing that harm. I don't think that we need a lot of questions on this. Obviously, folks can clarify why we're doing this, but I also think that it is obvious, and I would like us to think about the impact when we work on issues like this, and I'm eager for us to close this loophole and create this protection. Thank you very much for being here and for telling your story when you absolutely don't have to.
Representative Mueller.
Thank you. If a offender gets a Spouse Abuse Act or whatever, and they get the domestic violence off the record because they complete probation, will their gun still be taken away for 8 years if they plead it down, or because sometimes they do plead down, or they complete probation and their terms of probation, will they still get the guns taken away?
Are you referring to a deferral on,
Yeah,
for the
the
first?
Spouse
for
Abuse
the-
Act, where if they complete probation and it's technically not on the record, but they, did commit the act.
For all intents and purposes, under that act, it's specifically stated that that's not considered a conviction, so it would not be covered under this
Oh, okay.
prohibition.
All right, thank you.
Representative Cerniglu.
Thank you. First of all, thank you for sharing your story and for your strength and bravery today. And Mr. Lowry, this is a question for you. Can you clarify to this committee what that means to be convicted for a misdemeanor? Like, what is that? Is that a threat? Is that, and what is that?
A misdemeanor is a classification of a crime that, by definition, is less than a year here in Michigan, short of a high court misdemeanors. But there's a specific list in this bill. It means assault and battery, assault, several types of assault, breaking and entering, vulnerable adult abuse, destruction of someone else's home or barn, stalking, criminal sexual conduct in the 4th degree, and use of telecoms with intent to harass and threaten. There's a very distinct list of crimes in this bill that are covered.
So this is, in most cases, a violent offense.
Yes.
Correct. So,
And
so we're not trying to take anyone's guns away who hasn't done anything violent.
Yes.
Is that correct? Okay.
And there's an additional layer of protection that the victim of the crime must be within this domestic relationship as well. So it's not anyone who just commits these crimes. It is a particular subset of people.
Thank you for clarifying that.
Representative Filler.
Thanks, Chair. And Representative Cerniglu, I guess I do want to kind of take on her question again, which was, I believe the question was, most of these offenses will be violent. And so I'm looking through something like, I don't know, is malicious destruction of property in there?
Yes.
Yes,
That
it
is. Yep.
Okay, all right. So you could, I don't know, key someone's car and then lose your right to a firearm, or I'm sorry, still have your right to a firearm, but then key your, spouse or ex's car and then lose your right to the firearm.
All of these crimes were chosen by people who have experience in prosecution of domestic violence. These are all crimes that are the result of domestic violence and are part of that escalating pattern that I mentioned earlier of increasing violence and are indicators of increased violence in the future. But oftentimes, domestic violence is charged as one of these crimes
Thanks, Heath.
that are listed.
Thank you so much. Thank you.
Thank you. I'll now call up Rick and Martha O'Melian from Moms Demand Action. Thank you, folks. And just to let mostly committee members know that we have about 10 more people to testify, so if you could please keep your comments and questions brief.
Hi, we're Rick and Martha O'Melian. We live in Kalamazoo County, near the town of Plainwell. It's about halfway between Grand Rapids and Kalamazoo. We want to thank the committee for inviting us today to speak in support of these domestic violence offenders restrictions bills that you've been talking about, HB 4945 and 4946. And we thank you for considering them. You've heard some testimony already, and we're going to talk about the trauma that we hold, too.
We are survivors of domestic violence, gun violence. We speak today as grieving parents. Our daughter Maggie Wardle was murdered by an ex-boyfriend on October 18th in 1999. And even though it was 1999, I wake up every morning and go to sleep at night with the same feeling that my daughter was murdered. Maggie was killed on October 18th, 1999 in a dormitory room at Kalamazoo College. Her attacker bought the shotgun using a driver's license with his college address on it from a local firearms dealer in Kalamazoo. He bought it a week earlier and hid it in his room before he lured Maggie into his room and killed himself after stealing Maggie's life. Maggie grew up not far from where she attended college. She excelled in classes at Plainwell High School, and after visiting other colleges, she decided to attend Kalamazoo College. We were happy with that, so she would be close to home and safe. In her freshman year at K, in January of 1999, she met him, and they started dating. On a small campus, he was able to see everything she was doing and who she talked to. After Maggie died, we all realized how much he emotionally abused her and exerted control over her without apparent physical abuse. He stalked, complained, apologized, and threatened to hurt himself if she left him. The extent of his abuse against Maggie in front of his or her friends was not recognized. But he had problems in his previous relationships. We don't know any details, but he openly showed his anger with others over the 2 years he was a student at K. She broke up with him that spring and into summer, but each time he forced his way back into her life, playing on her feelings for him and threatening to hurt himself. When she came back to K in August, she told her friends it was all over. It actually was the most dangerous time for her as he stalked her and watched.
So today we speak in support of these bills, which are personally impactful for us. They would impose firearm ownership restrictions on those with domestic violence misdemeanor convictions to protect women and children and families. When this happened to Maggie, there were not protections for dating violence victims under the domestic violence laws at that time. These bills that you're talking about today, when passed and enforced in Michigan, can support current laws and protective order procedures, which together can save the life of someone like Maggie in the future. Over 4.5 million women in the U.S. have reported being threatened with a gun by an intimate partner. Nearly 1 million women alive today have reported being shot or shot at by intimate partners. In some instances with these bills today, we can stop these potentially dangerous situations before a firearm is used. A convicted domestic violence offender, male or female, has shown by their past behavior and abuse that access to a firearm is not appropriate. This is not a violation of their rights. It's not a threat to those who are responsible gun owners, but it is a reasonable reaction to past behavior and the history of the abuser. Before Maggie died, we did not understand as her parents the extent of his abusive need for power and control over her. She was emotionally abused by him in their interactions and made to feel she owed him her understanding. He was not physically abusive. He was not charged with domestic violence in his past, but he did show others red flag behaviors, as Martha mentioned, that he could hurt himself. And he was angry with her that year, and he bought a gun. Purchasing that shotgun and hiding in his dorm room for a week was his final threat of power and control to our beautiful, strong, assertive daughter, and he didn't like that assertiveness. He believed that accessible firearm was his power, his last chance to stop her bright future, the one without him in it. The moment that he pulled out that shotgun from under his mattress for Maggie to see is forever etched in our minds. If Maggie had been able to leave that room because that gun was not in that room, she might have survived his anger again. If laws existed like the bills you're considering today and were in place, we would have helped Maggie in any way possible, just like we always did. These bills will save someone's life and give them the chance to live a full, meaningful life, the chance Maggie did not get. Many instances of gun violence, like the violence that took Maggie, that you heard about earlier, are fueled by domestic violence and misogyny. Our story of Maggie and what happened to her right in front of us happened in 1999. Each year in Michigan, since then, women and children in increasing numbers have been killed in domestic violence tragedies. About 10 days ago, in a domestic violence vigil by End Gun Violence in Michigan, on the Capitol steps, they displayed 70 pairs of shoes representing the 50 women and 20 children killed in domestic violence in Michigan annually. 2 such tragedies just this year made us sadly think about what happened to Maggie, because the pattern of abuse that those women endured and how they tried to end the relationship was familiar to us. In January of this year in West Michigan, a young mother was murdered by her controlling, longtime boyfriend. He killed her and her 2 young daughters, then killed himself. She was planning to end the relationship, and it was in the midst of packing to leave with her 2 kids, 13 and 10, before the shootings. And in July of this year, a woman in Saline, Michigan, was killed by her ex-boyfriend after she filed for a protective order against him after years of physical and emotional abuse and calls to law enforcement, which she had cited in the order. The order had been granted, but not yet served. In each instance, the abuser had access to a firearm despite past abusive behavior. It appears that one of the abusers may have had a past domestic violence misdemeanor conviction on his record, but no law like you are considering today was in place. These bills you vote on won't end all domestic violence, gun violence, or stop all other means of violence that you might want to consider. It won't address mental health issues of those who are at risk of hurting themselves or others. You'll have to pass other laws to do that, and you should. Today we're asking that you vote on and pass these bills and save lives one at a time. Thank you.
Thank you. Representative Arbit.
Thank you, Madam Chair, and thank you so much for being here. I could think of nothing more as a testament to Maggie's memory than you guys and your advocacy. I just want to make just a brief statement. I think, in this committee, we deal a lot with penalties and with, enhancing penalties and strengthening, the reach of the criminal justice system. And sometimes it can be a struggle and almost grasping at straws to connect the work that we do with prevention. And with actually preventing a crime versus punishing people for a crime. I think this is one of the clearest cases that we have ever had before this committee of something that does strengthen a penalty, but actually acts as a very clear prevention mechanism. So I am very excited to vote yes on this legislation, and I think it could not be a moment too soon. So,
Representative Breen.
Thank you, Chair. My question is more for the bill sponsor, but to the parents sitting in front of me. Thank you for sharing the story of your daughter's life, and to all the victims in the room. We're going to do our best to protect you and make sure we have as few victims as possible. Representative O'Neill, I am fully in support. This is my question. How can we make it better? And my concern here is with the logistics of it. How do we make sure that people who have these prior convictions or people who are re-entering our society if they are coming from prison or jail do not have these weapons? And I see this as a part that is missing, as in with our PPO statute, to make sure that there is a relinquishment process. Again, these bills, this is what we do need, but that is my concern. I'm happy to work with you. We may have something in the works already to ensure that there is a process that the people who do not have firearms actually do not have firearms, and I look forward to working with some of our partners in law enforcement with that, because just because the law says you cannot have a gun, I would like to make sure that they actually already relinquish any firearms that they have, that there is a mechanism in place to ensure that they do not have access, to ensure that if they are convicted of any of these crimes, that if they attempt to purchase, that there is something in place to ensure that there is a follow-up. Because right now we do have some glaring holes in our system where it might be a federal crime to purchase a gun if you are a prohibited person, but nothing as far as a state law. So thank you for bringing these forward, and let's talk about what we can do to strengthen these. Thank you.
Thank you, Mr. and Mrs. O'Melian. Appreciate your testimony on this difficult topic, and I am sorry for your loss. We'll now have Jen Polyukonis and Dr. April Zioli, who's on Zoom, testify. If you folks could please keep your testimony brief. We are kind of running over, so thank you.
Should I go first?
Sure, yeah.
All right. Chair Hope, Vice Chairs, members of the committee, I'm the Policy and Programming Director at the Johns Hopkins Center for Gun Violence Solutions. My name is Jen Polyukonis. Kudos on the pronunciation. My testimony today is offered by me as an individual and does not represent the views of Johns Hopkins University. I urge the committee today to support House Bill 4945 and 4946. The stories that we heard today are not anomalies. Domestic violence is a serious problem in the United States, impacting women, children, and communities in states all over the country. According to the CDC, in a report from 2020, over 12 million adults in the U.S. were victims of domestic violence. And the combination of guns and domestic violence can create a deadly escalation of harm. Guns are used to threaten, injure, and kill in situations of family abuse. Nearly half of all women killed in the United States are killed by a current or former intimate partner, and more than half of those homicides were committed with a gun. An abused woman is 5 times more likely to be killed by an abuser when there's a firearm present. And in fact, more than a quarter of the homicides in the United States are related to domestic violence, and they increase the chance that there will be multiple victims. In Michigan in 2020, there were 111 domestic violence-related homicides. 58% of those were committed with a firearm. And domestic firearm violence also impacts the victim's children, other family members, current partners, and friends. Domestic abusers with access to firearms can inflict harm on more than just their intimate partner. This is a community problem. A 16-state study found that 20% of intimate partner homicides involved additional victims, including strangers and bystanders. And additionally, a study from Hopkins at my own center at Johns Hopkins found that 60% of mass shootings, the shooting was either a domestic violence incident or the shooter did have a history of domestic violence. We're going to hear from Professor April Zioli next, so I don't want to go into too much of her research since we'll get to hear her voice. But laws preventing access to domestic abusers are associated with a reduction in intimate partner homicide. This is an important step in protecting women and families and children from domestic abusers and their access to guns. And I also would be remiss if I didn't acknowledge Representative Breen's comment about a relinquishment process. As Professor Zioli is going to talk about, studies show stronger correlation with reducing intimate partner homicide when there are strong relinquishment processes. This is a public health crisis, and it needs to be addressed, and it should have been addressed yesterday or the day before, because as we know, this has been a problem that has been going on for too long. House Bill 4946 will be one important step to protecting women, children, and our entire communities from gun violence.
Thanks, Jen, for teeing me up. Thank you to our representatives for allowing me to speak today regarding the research evidence on domestic violence, firearms, and firearm policy. I'm the Policy Core Director for the University of Michigan's Institute for Firearm Injury Prevention. And I'm here as a gun policy and domestic violence expert who spent the last 20 years of my life focused on determining which gun safety laws are associated with reductions in intimate partner homicide and how best to implement them. For all of the reasons that we've heard today, it's critical that intimate partner violence offenders don't have access to guns. This bill's a first step in ensuring that those convicted of misdemeanor violence don't have access. The state-level misdemeanor domestic violence conviction firearm restriction can save lives. However, Research suggests that this misdemeanor firearm restriction must be implemented to save lives. Research that examined the association of state-level firearm restrictions for individuals convicted of misdemeanor crimes of domestic violence found that they were associated with lower rates of homicide among pregnant and postpartum women. The majority of pregnant and postpartum women who are killed by their intimate partners. And in fact, homicide is the leading cause of death for pregnant and postpartum women. But the lives were saved only when the state law included language requiring that individuals prohibited from firearm possession relinquish the firearms they already have. This was associated with 3.74 fewer deaths per 100,000 live births than in the absence of the law. To repeat, researchers have only found an effect of these state laws on homicide when it's paired with a relinquishment provision, and many states do this. And this makes sense. If we allow domestic violence offenders to keep their weapons after we prohibit them from having them, to keep them by default, we can't expect that the firearm restriction law will save lives. The bill put forward does not include language requiring offenders to relinquish the guns they already possess. And I would ask the legislators to think carefully about whether and how offenders will lose access to their guns if there's no mechanism in the law to make sure that this happens. This bill is a step forward towards ensuring that domestic violence offenders don't have access to firearms. Reducing access to firearms for this group will save lives. There's more we can do, as suggested by the research evidence, but it is important that we lay the groundwork and start somewhere. Thank you.
Representative Breen.
Thank you, Madam Chair. I think you just hit the nail on the head. Thank you for your testimony. We do need a relinquishment process. We previously passed legislation. I'd like to thank our partners in law enforcement, particularly the sheriffs, chiefs of police, and the Fraternal Order of Police, because we earned their support on that portion of the bill where we did have a relinquishment process. And we may be able to do something in a separate bill or with an amendment, Representative O'Neill, to make this as strong and as impactful as possible. My other question to anybody up here is that I believe there is a federal law in place as far as domestic violence charges and whether or not somebody can possess a firearm. If so, and there's a federal law, how close is this to that federal law? And does the federal law maybe even itself provide a relinquishment process, or is that still a hole that we need to fill?
I can answer that. The federal law is a lifetime prohibition for convictions of misdemeanor domestic violence. And there are some differences between the definition of misdemeanor domestic violence in the federal bill versus Michigan, or federal law versus Michigan's bill. For example, a big, aside from the lifetime versus time limited difference is that this Michigan bill is more expansive and would cover, more convictions that are associated with domestic violence than the federal law does. The federal law does not have a relinquishment provision. That is a pretty big hole. And we know that it is not enforced to a great degree across the country and here in Michigan.
Thank you.
Thank you. Thank you for your testimony. And very briefly, Danielle Russo-Bennett and Linus Banghart-Lynn from the Department of Attorney General.
And filler and members of this House committee. Thank you for having me here to have the opportunity to speak about what I would consider critical and very important legislation. As you heard, my name is Danielle Russo-Bennett, and I am the lead attorney of the Michigan Department of General's Domestic Violence and Sexual Assault Unit. I am the supervisor of our Special Victims Unit for the Criminal Trials and Appeals Division. I'm also the head of the SACI program around the state. And just want to note that 20 years ago, when I was a very young prosecutor, I started as a domestic violence prosecutor in Wayne County. It's the first cases that my hands ever touched and my feet ever went into a courtroom to handle. I am here in my capacity to speak about my experience in handling these type of crimes and talk about how I think that this bill can impact these type of devastating crimes. My unit is grant funded. I handle domestic violence, sexual assault, stalking, and unfortunately I handle homicide cases as well. I've been specifically trained in my role as a prosecutor to be victim centered, offender focused, and trauma informed. I uniquely and unfortunately understand the connection between guns and domestic violence. With me here today is also Linus Banghard-Linn. He's our department's chief, acting chief legal counsel. He's also worked in our Solicitor General division. He's here to answer any legal questions you might have on our federal or state Supreme Court legality questions. But I am here in support of these bills to prevent people convicted of domestic violence misdemeanors from owning or possessing guns. Further, using, transporting, selling, transporting. You know the language of the bill. Anybody that has been convicted of a domestic violence misdemeanor. We've talked already, I've heard it mentioned that it's an 8-year ban on firearms for this perpetrator convicted of this offense, unless they've paid all the fines. They have to pay all the fines, all their incarceration, their probation. They have to finish anything that was imposed as part of this conviction. Our department applauds Senator Chang and Representative O'Neill for introducing this significant legislation. And I'm proud to be here today as a longtime domestic violence prosecutor. These bills will protect victims of domestic violence. It's a common sense measure that is long overdue, and I do believe it will make our communities safer. Domestic violence and firearms are a deadly combination, and as we know, a lot of us in the business, survivors are at the greatest risk of harm and potential homicide after leaving or attempting to leave these abusive relationships. We've already heard some statistics from the last speaker. I'd like to throw a few more at this committee. Abusers with firearms are 5 times more likely to kill their female victims than abusers without firearms. Every month, an average of 70 people are shot and killed by an intimate partner. Nearly 1 million women alive today have reported being shot or shot at by an intimate partner. Over 4.5 million women have reported being threatened with a gun by an intimate partner. And this study also found that while deadly intersection of guns and intimate partner violence affects all women, it has a disproportionate effect on women of color, as well as pregnant women and postpartum women. We also see segments of the LGBTQ community, people with disabilities, that are highly vulnerable to this type of abuse. To say these statistics are shocking is an understatement. I'm infuriated with the cases that come across my desk every day, that thousands of Michigan residents are targeted each year by the scourge of senseless and preventable gun violence in our state. Legislation like this and Michigan's newly passed extreme risk protection orders, they're simply practical and effective tools to combat gun violence. Once enacted, common sense measures like this will remove deadly weapons from the hands of people who have been convicted of violence against the people that they purport to love the most. The Department of Attorney General is committed to protecting and supporting survivors. That includes being here today to support legislation like this, which will reduce the number of gun-related deaths caused by intimate partners. I've heard already mention of the federal law. Federal law does currently prohibit the purchase and possession of firearms and ammunition by people who have been convicted of a misdemeanor crime of domestic violence. But let me point out, state and county police and prosecutors cannot hold accountable people under these federal laws, which is why we need, as a state prosecutor, these additional further protections for victim survivors at the state and local level. With this legislation, we would be joining the overwhelming number of other states that have closed this gap in the federal law pertaining to people who commit crimes of domestic violence. 33 states across our country and Washington, D.C. already have laws on the books, have these domestic violence misdemeanor gun prohibition statutes. And these states range, I might add, in geographical location and political beliefs. It demonstrates that this measure has widespread bipartisan support.
Ma'am, are you nearly finished?
Yes, I am, yes. I believe at this point, if you have any questions, anything that you would want to ask either Mr. Banghart-Linn or myself, we are available for any questions. I just thank you so much for giving me an opportunity to be here.
Thank you, and I'm sorry to cut your testimony short. If it makes you feel any better, I also cut your boss's testimony short, so.
That actually does, thank you.
I just have a quick question, clarification. I recognize the importance of thinking about relinquishment, and we in the past, when we've talked about punitive measures around other issues, we have been comfortable with talking about the implementation after the fact so that we can make progress on that issue. I certainly believe we could resolve the relinquishment issue without slowing this down and getting in the way of it passing. But I just want to get on the record that we do support this legislation as it is, with the understanding that we need to address relinquishment either now or later, correct?
Yes, absolutely. And I think it's going to be a collaborative effort with law enforcement, the courts, and prosecutors as well.
Okay, thank you.
Representative Cerniglu, can you please be quick?
I can certainly try. Thank you. So I just want to say, I think that anyone, who has experienced or witnessed domestic violence knows that this is a very unique crime. This is a very unique space, and we know that it's not isolated, that it's an ongoing process. And I just wanted to, I know that we have some committee members from the law enforcement field who have likely had experience, from this as well. And I wanted to thank them for their past dedication, to victims and protecting victims. And I also wanted to ask a question of, I think, the bill sponsor, Representative O'Neill. What would you say to anyone, that was concerned that this was simply an infringement on Second Amendment rights? What would your, rather than a reasonable restriction, how would you frame that?
Thank you. Thank you for that question. I would start off by asking if the individual was a parent. First of all, I'm a father of 3 daughters, and I know many of us here have daughters. I think it's responsible for us to protect our daughters and sons, because it happens on both sides. And any reasonable, clear-minded thinking individual will agree that this is just common sense steps to take care of safety for our families. And so I'm a Second Amendment person. I love to hunt and fish. I own many weapons. And so it's not, and I would say to those who try to make the past that this is an infringement on Second Amendment rights, I would say enough is enough. I mean, just stop it. Just stop it, because that's not the case. We're here as legislators. It's our jobs. One of our jobs is to protect our citizenship. And the statistic doesn't lie. You look at the data, and I'm sure everybody in this room have been directly impacted by it. Domestic violence have been indirectly impacted by it based on just life. So it's our job to make sure we keep people safe. And so that's what I would say. I could say more, but this is common sense stuff. It's not rocket science, and it's the right thing to do right now.
Thank you. I am going to cut off questions for the time being, just because we do have 10 bills and 9 subs to get through. But before we move on, Mr. Lambert from Michigan Open Carry. briefly, please.
Members of the committee, thank you very much for your time today and for the opportunity to speak. My name is Tom Lambert. I am the Legislative Director for Michigan Open Carry, here to testify in opposition to these bills. We frequently hear in the gun community that the anti-gun community isn't actually about stopping violence, it's about control. We also hear very frequently that the anti-gun community doesn't understand our existing laws, which is why they continue to push for more that don't make sense. Both of those things are absolutely front and center today. And to be clear, none of this takes away from any of the very harrowing stories that you've heard today. They are not the problem. The problem is they are being lied to. They're being lied to that these bills would help their very unfortunate situations. The reason is, nothing in these bills.
Sir, I don't appreciate you commenting on what may or may not have been said to these folks who've lost loved ones and experienced violence themselves.
I've heard plenty of testimony here today that has been absolutely incorrect, and I will restate that nothing in these bills would help their situations, and I'm happy to explain exactly how that is.
If you can do so briefly.
The reason is, nothing in these bills focuses on violence. We've heard lots of stuff about violence today. Concerning violence, absolutely. But these bills don't focus on violence. They completely missed the absolute most important part of what we're here to do today. They don't focus on violence. There was a question about, well, do these actually focus on things that include violent acts? And the answer was, well, in that person's experience, these are prosecutions related to domestic violence. Well, if we look at the sections that are listed here in the Penal Code, they include misdemeanor offenses, such as making an unsolicited commercial call after the hours of 9 p.m. That would cause somebody to lose their gun rights if they happen to do it to somebody that had a domestic relationship to them. Now, I'm not making any defense for making an unsolicited commercial call after the hours of 9 p.m. I only suggest to you that it shouldn't result in somebody losing their firearm rights for roughly 8 to 15 years. Using a telecommunications device where they use indecent language and it results in the other person being annoyed, that would cause somebody to lose their firearm rights under these bills. Entering someone's ice shanty valued at over $100, regardless of whether the ice shanty is occupied or not without the person's permission, would cause somebody to lose their gun rights for 8 to 15 years. I suggest to you that all of these things, again, have nothing to do with violence. Because if you look in the definition of what the misdemeanor domestic violence means, it says all of the misdemeanors in the sections listed. And these sections include many, many, many misdemeanors that, again, have absolutely nothing to do about violence. We've heard, well...
Sir, I think you've made your point. Is there more to your testimony?
Absolutely. We've heard enough is enough when it comes to, well, what if this violates the Second Amendment? Okay, well, circuit courts across the country, federal circuit courts, are already striking down felony prohibitions based on nonviolent felonies. How do you think those courts are going to handle prohibitions based on nonviolent misdemeanors? But hey, enough is enough. We've also heard that the clearest cases that we've ever had showing that this is why we need this. Oh, I'm not sure how entering the ice shanty of another is the clearest case we've ever heard that we need these bills, but I didn't make the comment. We've also heard that it's a lifetime prohibition under federal law that is false. We've heard that more there are more convictions associated with domestic violence under federal law, or more in this bill than federal law, which not associated with domestic violence. There's more convictions in this bill, but again, they're not associated with domestic violence. To this point that this is said to mirror federal law and apply federal law to the state, again, the statement is 100% absolutely false. You also have issues with First Amendment in here. You can make comments, get a misdemeanor, be prohibited from having your firearm rights. There's Fifth Amendment takings issues in here with regards to the person being able to sell their firearms.
Thank you, sir.
I've also been part of a case.
Thank you, sir. We need to move on.
No questions? Thank you very much for your time.
And while we're transitioning from one subject to the next, I am going to call for votes. I would like to mention, though, several folks did submit cards in support. Their cards will be part of the record. We'll now have votes on House Bills 4624 through 4633. We took testimony on these on September 12th and September 19th. Representative Andrews moves to adopt the H2 substitute for HB 4624, excuse me. Madam Clerk, please call the vote.
To adopt the substitute H2 to House Bill 4624, Chair Hope.
Yes.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Sternaglu,
Yes.
Filler.
Chair, a quick question. These are the substitutes. I was just checking. Is there going to be any explanation of the substitutes today?
No, we're voting.
Okay. Pass.
Mueller,
Pass.
Bazat,
Pass.
Harris,
Pass.
Bagul.
Pass.
Madam Chair, you have, did I get every?
We got all of us? Yeah.
Okay.
Everybody voted? Yes, yeah. Okay, pass, yes.
You have 8 yeas, 0 nays, 5 pass. The substitute is adopted.
Thank you. Representative Carter moves to report HB 4624 with recommendation as substitute H2. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Sternaglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. House Bill 4624 is reported with recommendation as substitute H2.
Thank you. Representative Breen moves to adopt the H1 substitute for HB 4625. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Sternaglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. The substitute is adopted.
Thank you. Representative Young moves to report HB 4625 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Sternaglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4625 is reported with recommendation as substitute H1.
Thank you. Representative Arbit moves to adopt the H1 substitute for House Bill 4626. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Sternaglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. The substitute to House Bill 4626 is adopted.
Representative Devendorf moves to report HB 4626 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Sternaglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4626 is reported with recommendation as substitute H1.
Thank you. Representative Sternaglu moves to adopt the H1 substitute for HB 4627. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Sure, just to be clear, this is the substitute for House Bill 4627, is that correct? Okay, pass.
Representatives Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. The substitute H1 to House Bill 4627 is adopted.
Representative Andrews moves to report HB 4627 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. House Bill 4627 is reported with recommendation as substitute H1.
Representative Carter moves to adopt the H1 substitute for HB 4628. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. Substitute H1 to House Bill 4628 is adopted.
Representative Breen moves to report HB 4628 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. House Bill 4628 is reported with recommendation as substitute H1.
Thank you. Representative Young moves to adopt the H1 substitute for HB 4629. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
Pass.
Bazat.
No.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 2 nays, 3 pass. The substitute is adopted.
Thank you. Representative Arbit moves to report HB 4629 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
Pass.
Bazat.
No.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 2 nays, 3 pass. House Bill 4629 is reported with recommendation as substitute H1.
Thank you. Representative Devendorf moves to adopt the H2 substitute for HB 4630. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. The H2 substitute is adopted. For House Bill 4630.
I lost my place here, sorry. Representative Cerniglu moves to report HB 4630 with recommendation as substitute H2. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. House Bill 4630 is reported with recommendation as substitute H2.
Representative Andrews moves to adopt the H1 substitute for HB 4631. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. The substitute H1 to House Bill 4631 is adopted.
Representative Carter moves to report HB 4631 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. House Bill 4631 is reported with recommendation as substitute H1.
Thank you. Representative Breen moves to report HB 4632 with recommendation. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Yes.
Bazat.
Pass.
Harris.
Pass.
Bagol.
Pass.
Madam Chair, you have 9 yeas, 0 nays, 4 pass. House Bill 4632 is reported with recommendation.
Representative Young moves to adopt the H1 substitute for HB 4633. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
Pass. Oh, wait, check that no on this one.
Okay, this is to adopt the substitute.
Yeah.
Okay. Bazat.
No.
Harris.
No.
Bagol.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Substitute H1 to House Bill 4633 is adopted.
Thank you. Representative Arbit moves to report HB 4633 with recommendation as substitute H1. Madam Clerk, please call the vote.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Madam Chair, I don't believe we took testimony on this one, so I look forward to talking with the sponsor or the chair, but I don't believe we took testimony, so I'm going to vote no. So, thank you.
Mueller.
No.
Bazat.
No.
Harris.
No.
Bagol.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. House Bill 4633 is reported with recommendation as substitute H1.
Thank you. And now, very briefly, and I'm sure that these folks know the definition of briefly, unlike some others. You can proceed when you're ready. We're taking testimony on House Bills 4945 and 4946. Oh, no, excuse me. 4718. My apologies.
No, all good. Thank you very much, Madam Chair. I will be very brief. If there are additional questions, everyone can feel free to get a hold of me outside, or I'm happy to come back next week as well. I want to thank you all for giving me the opportunity to testify on House Bill 4718, which is a bill to ban the LGBTQ panic defense in the state of Michigan. Back in 2013, the American Bar Association issued a unanimous resolution calling on federal, tribal, state, local, and territorial governments to prohibit the use of this defense. And just last week, Delaware became the 18th state to do so. This would bring us up to number 19. Likely the most notable use of the LGBTQ panic defense for most of the members of this committee was its use in the 1998 murder of Matthew Shepard, where two men stated that the discovery of Matt being gay and their fear that he might make a pass at them led them to beat him and tie him to a fence, after which he spent 6 days in the hospital and ultimately died. However, this defense is more contemporaneously used in an effort to lessen the penalties for assault of crimes against and murders of trans people, particularly Black trans women. Violent crimes against the trans community have been on the rise over the last 2 years, with the vast majority of those being against Black trans individuals. The LGBTQ panic defense is often deployed as a component of other defenses, to play on the unfortunate prejudices of some judges and juries in an effort to mitigate penalties for these crimes. At its very core, this defense asserts that the crimes against the community carry less weight because we are inherently less human and therefore less valuable. What I am asking the committee to do today is to reject that notion. Thank you, and I will hand it over to Emmy.
Thank you. My name is Emmy Zanatti. I'm the Director of Advocacy and Civic Engagement at Equality Michigan, our state's largest statewide advocacy organization dedicated to LGBTQ equality and civil rights. I want to thank Chair Hope and the committee for allowing me to speak today, and thank you to Speaker Pro Tem Pohutsky for putting forward House Bill 4718. I'll start by saying Equality Michigan wholly and unequivocally supports this bill to explicitly prohibit the use of the legal tactic, the gay and transgender panic defense, or the LGBTQ panic defense that Representative Pohutsky described. The tactic obviously seeks to partially or completely excuse violent crimes, including homicide, just simply because someone is surprised, triggered, or caught off guard by another person's real or perceived status as an LGBTQ community member. The American Bar Association in 2013 issued a unanimous resolution calling on all forms of government in our country to prohibit this use as a defense strategy, and that's beyond pertinent in today's climate. The defense is documented to having been used since the 1960s. It has been used in at least 35 states that we know of. Michigan ranks 6th in all the states in the country in terms of the number of times it's been documented to having been used. What's more, in over half of these documented instances of the panic defense being used, violent crimes were committed during the defendant's attempted robbery of the victim. Of the 80 cases where a relationship was determined or known, the defendant and between the defendant and the victim, a pre-existing relationship existed in 30 homicides. Given the above, I'd like to first establish that using the panic defense, even as a sincere defense mechanism, is an egregious abuse of the social contract we should abide by as fellow human beings. Killing or assaulting someone simply because they aren't your type or it's not your ideology is an incredibly dangerous precedent to set, and one that wouldn't be entertained if it were the other way around when we're talking about sexuality and gender identity. Additionally, violence against the LGBTQ community remains high, alongside the heightened and unfounded rhetoric that seeks to spread malicious falsehoods and dehumanize LGBTQ people, often specifically transgender Americans. The ability and attempt to use the panic defense tactic only serves as additional fuel to the fire of those currently harboring provoked hostility towards the LGBTQ community. I know that the bills to give LGBTQ Michiganders basic non-discrimination protections and to protect youth from conversion therapy turned out to be more contentious than our community members would have hoped for. Nevertheless, I hope all the members of this committee and this esteemed chamber can see their way to agreeing that being ideologically opposed to a person's existence, or even ideologically opposed to your own physical attraction to that person, and the justification of murdering them because of it, is plainly morally bankrupt. So I ask you once again to support House Bill 4718. I thank you once more to Chair Hope and the committee, and to the Speaker Pro Tem for putting this bill forward, and I appreciate the committee's time and consideration.
Thank you. Dakota?
Thank you, Chair and members of the committee. My name is Dakota Trolsky. I am the State Director for HRC in Michigan. On behalf of its thousands of supporters in Michigan and 3 million members and supporters nationwide, the Human Rights Campaign thanks you for the opportunity to submit testimony to help inform your deliberation on HB 4718. We strongly support this legislation, and it is our hope that the committee will advance it. The Human Rights Campaign is America's largest civil rights organization working to achieve lesbian, gay, bisexual, transgender, and queer equality. By inspiring and engaging all Americans, HRC strives to end discrimination against LGBT+ citizens and realize a nation that achieves fundamental fairness and equality for all. HRC believes that HB 4718 is an important measure that will ensure victims of violent crimes and their families obtain equal justice, regardless of their sexual orientation or gender identity. Quote-unquote panic defenses provide perpetrators with justification for committing violent acts towards the LGBT+ community. The use of panic defense allows a criminal defendant to argue in court that their discovery of the victim's sexual orientation or gender identity caused the defendant's violent reaction. Measures such as HB 4718 provide a firm stance that LGBT+ lives are not worth any less than others, and that one's sexual orientation or gender identity will not serve as a justifiable reason for acts of violence to be committed against them. HRC has officially recorded over 300 violent deaths of transgender and gender nonconforming people since the organization began tracking this violence 10 years ago. Additionally, statistics from the FBI show that LGBTQ+ people are disproportionately targeted in acts of hate crime. Despite hate crime legislations being enacted federally and throughout the U.S., courts are still seeing the use of panic defenses used in hundreds of defense arguments, such as the defense of insanity, diminished capacity, provocation, and self-defense. Even in cases where perpetrators are not fully acquitted as a result of one of these LGBT+ panic defenses, we have seen the defense result in the lessening of punishments during sentencing and even result in hung juries. In 2013, the American Bar Association passed a resolution declaring that an individual's sexual orientation or gender identity does not trigger in another person a medical or psychological panic, does not constitute legally adequate provocation, and does not make a person more threatening. The ABA urged legislatures to prohibit the use of LGBT+ panic defenses in order to prevent discrimination against and protect LGBT+ individuals. 18 states, as mentioned, as well as Washington, D.C., have passed legislation that bans most gay and transgender panic defenses. California was the first state to pass anti-panic defense legislation in 2014, and with New Hampshire and Delaware being the most recent in 2023, it is our hope that with our support, Michigan, as well as the remaining 32 states, will do the same. The enactment of HB 4017 will send a clear, concise, firm message that Michigan will not support the notion of one's sexual orientation or gender identity can serve as a justification or legal defense to criminal acts of violence. Thank you for the opportunity to submit testimony. We request that you swiftly pass this legislation.
Thank you very much. We would have time for like one question. Seeing none, I believe the bill sponsor and the folks who've testified this morning so briefly, and I appreciate that, are going to make themselves available offline to answer any questions or concerns, and I appreciate that.
Of course. And Madam Chair, Anjali Martel from the LGBTQ section of the State Bar was also available via Zoom. So if there are more like legally centered questions, we also have resources for those as well. I'm not sure if she's still on.
Okay. Okay, thank you very much.
Thank you.
Just so everyone is assured, any cards turned into the chair will be recorded in the minutes. There being no further business before this committee, we are adjourned.